I know that I don't have equal rights in that courtroom to be able to access information that I might have stored electronically. Because they are looking at the threat of arrest, incarceration, because they brought their cell phone with them. And all of those things, quite honestly, are tantamount to, taking away people's civil rights under the color of law, because it's going to be enforced by law enforcement at the end of a barrel of a gun.
Hey, Shalom. So this video here is going to be more of an unpacking of the letter that we P.A.T.A. has sent to the Supreme Court Justice, the Honorable Mary Jane Theis, I believe. And we're joined by a special guest. He's a subscriber to the channel, a follower of the channel, and he is a avid First Amendment as well as other amendment supporter. This is JD, who's going to be joining us to discuss this letter and his perspectives on things. Say hi to JD to the people. He's joining us by phone.
Hey there, people. This is JD, and Shannon, it's a pleasure to be here on the show with you today and to talk with you about this issue with the Illinois Supreme Court policy on portable electronic devices and what Macon County has done, and just the unfairness of how this policy has been implemented to date.
Absolutely. So there's a few problems that ProveAllThings has with this policy that is put in place in Macon County, and also there are similar policies in other counties in Illinois that are improper because they quell the rights of the people, especially when we're going to get into this topic, especially the right of self-represented litigants to defend themselves. So this is a lot more than, hey, I just want to go into a courtroom a courthouse and film people and what's going on in transparency. This is deeper than that. There are actually violations against defendants to properly mount a defense. There's violations against them. So they're not getting due process because of these unfair, unjust, and frankly unconstitutional rules and policies that these courts are implementing. So we're going to unpack this letter piece by piece to further explain for those who really care about our rights what's going on here in the state of Illinois. And we're going to focus on Macon County, but make no mistake, as we're going to talk about here shortly, this is an issue that is beyond just Macon County. So this letter P.A.T.A. sent to the judge a couple days ago, as well as emailed to the judge and also other powers that be. And to this point, I've heard nothing back, which I can't say I've expected to hear anything back from this letter quite yet, because it was just recently sent out. But as far as the Macon County judge goes, he's had ample time to reach out, and he has not bothered to do so. In no way, shape, or form. Not a phone call, not an email, nothing. And I've called more than once, and I have not received even one phone call. So imagine if you go to court and you just quit going when you're supposed to be there. You're going to be held liable for that. They're going to put out a warrant for you. You're going to be arrested by armed men. They're going to make you pay attention. You don't have the option of just ignoring it. But that's exactly what is happening with this jurisdiction as well as others, especially when it comes to FOIA requests lately and things of that nature. A lot of jurisdictions have just adopted the attitude of ignore him. Who's going to hold us responsible? Let's just ignore him. We don't want to bother with that, which is definitely a problem in itself, and we'll be diving deeper into those issues as well in another video. So let's get on to this situation here. I went to the courthouse on August 2nd, and I was following up to see if they removed the signs they had there before, discouraging people to bring phones, into the courthouse, and direct defiance of the policy that the Illinois Supreme Court established back in January of 2022, and they did not remove those signs. JD, have you had a chance to thoroughly look at the video and read the letter and see what the problems are that Macon County is having here with their policy?
Well, absolutely. I did see the video, watched it several times, and took notes on, what I had reviewed, in considering the conversation that we're going to have. And I've read the letter as well. And absolutely, the letter, the focus here, I guess, I'm just going to back up from my perspective, but as I understand, the focus is the implementation of the Illinois Supreme Court policy on portable electronic devices. And it was clear that when you read what the policy of the Supreme Court said, that what is done in Macon County is completely contrary to that policy. And that's troubling to me as a citizen, as a person, because I know that I have no rights there that I should have, and if I'm a litigant, if I'm someone who is in the court system, either as a plaintiff, a defendant, a petitioner, a respondent, I know that I don't have equal rights in that courtroom to be able to access information that I might have stored electronically.
Correct. The initial policy established by the Supreme Court clearly outlined the need for the public in this day and age we're in today, where cell phones are so prevalent, and a lot of things are done by cell phone, internet, this type of thing, such as getting a ride to the court, getting a ride from the court, calling your place of employment if there was going to be some type of delay or problem. It was very clearly outlined and strongly encouraged that courts allow cell phones to be freely brought into the courthouse by anyone attending the courthouse. Now, that isn't to say that they would be allowed to record in the courthouse, but the physical device was encouraged to be allowed to be brought into the courthouse if, not abused, turned to silent, and, not, of course, not used to do anything that's improper. But at the very least, the directive from the Illinois Supreme Court indicated that, hey, if you're not going to allow the citizens to bring their portable electronic devices into the courthouse, you must at least hold it at the security point. So you must at least allow them to bring it in up to the security point and then check it at the security point, and then, of course, give it back when the person exits the security point on their way out. So that was pretty clear that was the policy of the Illinois Supreme Court. However, Macon County, for one, and I'm sure there's others, blatantly disregarded that rule. They claim that they have allowed it for 2 years when I did my last follow-up visit, but I don't believe that. And their signage is clearly contradicting that assertion that they have been willingly and allowing cell phones to be brought in and be checked for 2 years. What do you see about that situation, JD?
Well, when I read the policy of the Illinois Supreme Court, the first thing that the court did in great detail was outline and state the modern day needs of the people to be able to have their electronic devices, particularly in most of our cases, our cell phone. And for all of the reasons that you cited, they might need a ride. They might need to contact their employer. They might need to contact their family, whatever that case may be. And when you go further into the policy that the Supreme Court established, the first two tenets of the actual policy are that everybody should have the ability to bring their device in. And if not, there must be storage for it. But the second tenet of that policy, which I think is so important, is the fact that every litigant, and the language that the policy uses isn't may, must, or isn't may or might be able to have their devices available to them in court if they are there participating in the court, but it says they shall have those things available to them. And this is the policy of the Supreme Court, but yet it's not implemented in Macon County, obviously, and it's not implemented uniformly across the entire state.
Correct. That is very, very true. There is a lot of inconsistency, and the one of the craziest parts about this whole thing is, so the Illinois Supreme Court, they issued this policy January of 2022, and they required the courts to have a response or a some type of policy in place in regards to portable electronic devices. So Macon County whipped out a electronic device policy that quickly cited that they will not allow phones in due to security reasons and of that nature. I'm going to see if I can dig that up here real quick. And they quickly bid on to that, so they quickly found time to deal with that situation, and they almost made a mockery of everything. Did you look at that aspect of this, JD?
Well, I absolutely did. And the first thing that the Macon County presiding judge and the chief judge of the district, put in their policy document that they published, is it says, portable electronic devices being used in Macon County Courts facility can interfere with the administration of justice and may cause a threat to safety or security. As such, they are generally prohibited from being carried into the Macon County Court facility, except as provided in this order. And when you read the Macon County order, there's absolutely zero provision in there for a general citizen person, someone who is in the court system without an attorney, to bring in their personal electronic device. No possibility for it at all. And then on top of that, they provide no justification in their policy for that determination. Whereas if you read carefully in the Supreme Court policy, it clearly states that these are very limited instances where the administration of justice and threats to safety and security would be a real threat in the courts and in the court facilities. So I find the Macon County's policy on these devices to be extremely disingenuous.
Absolutely.
Absolutely. And the thing also is, as you wrote in your letter, they have made it almost impossible for the average person to know what their policy is, much less the average person wouldn't know what the Illinois Supreme Court policy is, because the average person doesn't really get into that at that level, even if they are participating in the court systems themselves. They are not trained attorneys. They do not look into these things, and they're being completely taken advantage of by this policy that Macon County has established. And when you look at it, further in terms of different examples across the state, you have no idea what to expect. It's just completely inconsistent and does nothing but add confusion for the average person.
Exactly. There is a on the screen here. I have the order from Macon County Administrative Order that was issued at the beginning of 2022 after the directive of the Illinois Supreme Court, and they are very blatant, bland in their rule, and I don't see anything that's clear and indicative that a person who is a self-represented litigant, it would be allowed to bring in their device. It clearly says persons admitted to practice law in the state of Illinois or admitted pro hac vici, I believe I'm saying that right, which means that they are covered under another attorney's license. So that's not the same as pro se. Members of the press in possession of and displaying credentials, but there's nothing that indicates that a person would be able to use that in their defense, as the Supreme Court rule indicates should be there, or the Supreme Court policy indicates that should be there. It's not. So think about this. If someone has an attorney on one side of the equation that is allowed to have access to the internet, allowed to have access to case law, allowed to have access to electronic evidence, and another person is crippled from having that same ability that's representing themselves, can you imagine how that skews the balance, the scales of justice, if you cripple one side of the equation to that point and then allow it on the other side, which is what they're doing. They're literally allowing tools and accessibility to one side of the equation, and under force and threat denying those same privileges and access to another side of the equation. This is why the Supreme Court rule was put in place. This is why this is not a joke. This is why this is not about harassing people or bothering people. This is real. People's lives and freedom are hanging on on these rules and on these policies. They mean something. That can mean the difference between somebody going to prison and not, because they're able to show or produce something that they're being scared out of even bringing into the court facility. This is a really big deal. JD.
Well, I think you touched on some very important things, and I want to unpack a few things from what you just said. You touched on the issue of rules, and you touched on the issue of policy. And the Macon County's policy comes out as their Order 2022-1 is, and it's an official administrative order that's signed off by the Chief Judge of the Judicial District. As well, it's signed off by the presiding judge of Macon County Circuit Court. And so it has the power and effect of a court order in that, respect, which the Supreme Court policy states that each, district, every circuit shall issue either an order or a rule. Now, when we talk about rules and policies, they are not the same thing. And this really it gets to the heart of, why further change is needed. The Supreme Court's policy was a great step in the right direction and is commended. But when you look at what the rule is in Macon County, the rule in Macon County hasn't changed since November of 2014, 7 years prior to the effectiveness of the Supreme Court's policy on electronic devices. As well, the Supreme Court never has issued a rule, and a rule is different than policy. And so we have that situation where they are, imposing this. And the thing is, consider what you just said before. You referred to the Supreme Court's policy as a rule. And that is because the average person like you, myself, we understand a policy of the Supreme Court to have the effect of rule, but does it? It really does not have that effect of rule. The courts and the judiciary have to work on the basis of Supreme Court rules. And those rules are binding, whereas the policy is not binding in the same way. And so you have these people who are caught up in the court system. They don't have the advantage of being able to access information, case law, especially case law, as you mentioned it. Because if you're arguing in a court case, and unfortunately I've had to argue in some of my court cases, against licensed attorneys. And when I've had to make those arguments, for them to, come up with a piece of case law off the cuff that I wasn't familiar with, I couldn't look that information up without an electronic device. I would be completely hamstrung because they had information, and I don't know how they're presenting the information from that case law in their argument contrary to mine. And so therefore, it puts every self-represented litigant who doesn't have an attorney completely at risk of being railroaded because they have not the means to properly defend themselves or to properly prosecute their issue, whether it be in the civil court or in the criminal court. It really doesn't matter. They are hamstrung because of the local court's policy that says, no, you can't have access to that information. And the reason why is because you're not a member of our special club, the Illinois Bar.
Yep. And another issue that's going on here is even their policy, Macon County Administrative Order 2022-1 is not available on their website. You actually have to Google this document and find it through the back door, so to speak. There is no direct way of seeing this policy on Macon County's website as of this video being made here on August 11th, 2023. There is no way to get to this policy directly from their website. So they've buried this in the internet in such a manner to where the average Joe can't find it. So there's a lot of violations going on with this court as far as their compliance with any judicial fair process. They've just basically decided, hey, we're going to run things our way. And it looks to me, based on the signage and other factors, they're just doing things to make themselves comfortable and to make things easier for them at the expense of due process for the defendants. It's a clear pattern here that the defendants are not respected, their rights aren't respected, a fair trial and fair justice is not being respected at all. You can see it clearly if you just pay attention. I mean, we can go back to just the signage itself when you first walk into the building. Even the city clerk side is greeted with giant threatening signs on the door that are there to chill you out of your First Amendment right to record. So this is the side of, on your screen here facing the court, which is still wrong because you haven't walked past the security checkpoint yet. But this same sign or signs are on the other side to your left when you walk in that threaten you with arrest. It clearly says you will be subject to arrest. You should never be subject to arrest if you record audio or visually in a city clerk's office. You shouldn't end up in jail behind that. And that's exactly what these signs are there to do, is to scare you and quell your right to record in those places that have nothing to do with the courtroom. Not even adjacent to a courtroom. Not even in the courthouse. These signs are unconstitutional and they should be removed, which is another thing that we have addressed to the Supreme Court, Illinois Supreme Court Justice. What do you think about those signs, JD?
Well, absolutely, I agree. You show in your letter to the Chief Justice that those signs, are absolutely chilling and are absolutely in no way in compliance with the spirit, if you will, of the Supreme Court's policy on devices. The first thing that you're greeted by outside of the courtroom is a sign that says, no cell phones allowed. And then when you walk in the door, there's signs that tell you, attention, no cell phones, you will be subject to arrest, with exclamation marks, very forceful language that, number one, the average person will never challenge, ever. And they aren't going to take what they need with them because they're fearful. They've had their whole perspective chilled, and it's chilled the people from exercising their rights, and from the people, acting in the spirit of the Supreme Court policy, because they are looking at the threat of arrest, incarceration, because they brought their cell phone with them.
Right.
And the reality is in those completely public spaces, there is a freedom of press, there is a freedom of speech, and it has been long established by the Supreme Court of the United States that people have a right to record and video in those areas, and that there is no reasonable right of privacy within a open and public space. So the whole effect of what Macon County is doing is to chill people and scare them and dissuade them from challenging or even exercising their rights or thinking about exercising their rights. And all of those things, quite honestly, are tantamount to, taking away people's civil rights under the color of law, because it's going to be enforced by law enforcement at the end of a barrel of a gun. And nobody is going to argue with the barrel of a gun when it's pointed at them and the cuffs are going on.
Right. That's true.
And so it's under the color of law that Macon County is violating people's rights, both in terms of freedom of press, freedom of speech, and violating the spirit of the Illinois Supreme Court's policy dealing with personal electronic devices, making the court system more equitable, more accessible, and less burdensome on the average individual.
Exactly. You said it very well, JD. I agree 100%. Macon County is definitely a court facility that has skirted the Supreme Court policy, and they have just skirted common sense. They have skirted due process, justice. A good judge and a good court would naturally want both sides of the equation, that'd be defendant and plaintiff, to have a equal shot at their case. And I would argue, even without this prodding by the Illinois Supreme Court, common sense would dictate that there should be provisions made, if someone's representing themselves, to allow them access to the same advantages that a bar attorney would have. That's just common sense, in my opinion. However, common sense is not always that common, and upon reading this this policy, you would feel as if a court and a presiding judge had any desire for justice, they would have used this as an opportunity, as a wake-up call, in essence, to say, oh my goodness, we haven't been doing this right. We've missed the boat on this. Let's correct this immediately. And it seems obvious to me that Macon County has tactically snaked their way around everything here in order to keep control over the self-represented litigants and the public as a whole. They want to keep people suppressed. They want to keep them under their thumb. They want to deny their rights for their own convenience and their own comfort. That seems to be the pattern that they have demonstrated with everything from their policy that they issued back in January 2022 to the signage outside of the courthouse to this day right here. That is all consistent with the mentality that I just stated. And we're going to stay focused on this situation until there's a change made for the people. So, are there any other points that you want to bring up, JD, with this situation?
Well, I want to add to what you just said. And it goes back to paragraph A of Macon County's policy on devices, which is their Administrative Order 2022-1. And it says that portable electronic devices can interfere with the administration of justice. Now, you talked about fairness before. And quite honestly, the action of the Macon County Court and presiding judge, Thomas Griffith, and the chief judge, Judge Rosenbaum, Randall Rosenbaum, serve to not empower a self-represented person in court, but to limit them. And it interferes, their very actions against the policy of the Supreme Court interfere with the administration of justice as it applies to the unrepresented litigant because of the handicap that it presents them with. Their own policy is an interference with the administration of justice. But they have their blinders on, and they look at it and they say, oh, well, we'll decide for you what's fair for you and what's not fair for you. Because we know best.
Yeah.
Well, the thing about, when you look at the founding fathers of the United States of America, they had enough of Great Britain telling them that Great Britain knew best and should, exert untold, power and leverage over the colonies, to the point where the colonies said enough is enough. And they declared their independence, and we fought the Revolutionary War.
Right.
And the founding fathers wrote the Constitution so we could have this level of freedom. The actions of these judges, as you point out in your letter, in your close to Chief Justice Theis, are in violation of the Supreme Court rules that actually are binding upon attorneys, binding upon the courts, binding upon the judiciary. And it is because of this interference in the administration of justice that Judge Randall and Judge Griffith have engaged in, that it is really necessary at this point, as you point out in your letter, for the Supreme Court to elevate its policy to a rule so that it becomes binding upon all the courts uniformly in Illinois, so that all the citizens know and all the people know what to expect when they go into the court system as to access to information and their devices and the tools that they can use to present their cases.
Absolutely. Well, P.A.T.As going to fight for this. We're not going to stop the fight. This is just the beginning. If nothing changes, then we're gonna dive deeper into this. This is definitely a miscarriage of justice for millions of people, I'm sure, in that state. So we appreciate JD for joining us today to discuss this letter. I would hope to have you on some more discussions. He's been an avid supporter of P.A.T.A. You can tell that he is an educated man. We appreciate his input on what we're doing. And yeah, we're going to stay on this whole situation until something gets resolved for the people. We're going to fight it out. So if you want to join us in that fight, please subscribe, join the channel. If you want to support monetarily, feel free to do that. Anything you can do is always appreciated. It helps us fight harder and expose more courts in Illinois and other places, if possible in the near future. We'd like to do that, but all that takes money. So we thank you for your time watching this video. If you see anything in this video that you don't like, you can feel free to reach out to your legislators and the people, the powers that be, and voice your opinion. As the public, you have the right to do that. JD, I will let you have the last word. Yes, sir.
Well, I just want to emphasize what you just said to your audience and your listeners. If this enrages you as much as it does us, this level of abuse on the people, contact the government in Macon County. Contact Judge Rosenbaum in the 6th Circuit. Contact the Illinois Supreme Court. Contact the media sources within the state of Illinois and let them hear your voice relative to this issue. Because this is not about one or two people. This is about literally millions of people. And every person, be they a citizen or a resident of the state of Illinois, be they a citizen of the United States of America, these rules impact everybody who might find themselves in the court systems of the state of Illinois. P.A.T.A., thank you for having me on. I appreciate the opportunity to be a part of your discussion. It's been great.
Appreciate you. We'll keep you updated. Comment below what you think about this video and what we've discussed. P.A.T.A. fam, we're out. Shalom.